All right. Good afternoon, everybody. As I was just introduced, my name is Ashley Bargenquast. I am the president of the criminal law section of the Contra Costa County Bar Association, as well as an associate at Tully & Weiss. I'm going to be presenting on filing under seal today, specifically California Rule of Court 2.551. This came to my attention as something that isn't commonly used in Contra Costa County when I appeared in front of a judge recently, just this past spring, and was told that they had never seen a motion to seal under Rule 2.551 before. And so clearly our bench is not familiar with it because we aren't bringing it. And so I wanted to make sure that we all had this tool in our toolbox and back pocket because it is really important. So let me start our PowerPoint. Okay, so as you can see, here we begin, California Rule of Court 2.551. As I mentioned before we started recording, this PowerPoint is available in the materials. So no need to take notes right now, you'll have a copy. Okay, so what I'm beginning with is the fact that, as you all know, attorneys have duties of confidentiality, the most famous being confidential information of a client. A member shall not reveal information protected from disclosure by Business and Professions Code 6068, which we all know as attorney-client privilege. I've included some language here from Rule 3-100 just so that you have it available for your motion to seal. This rule is also present in Rule 1.6 of ethics rules. Again, confidential information of a client. It's just that we cannot reveal information protected from disclosure unless really it's necessary to prevent a criminal act that we reasonably believe is likely to result in death of or substantial bodily harm to an individual. So clearly this is a really high bar, and we all know this. It's something that we deal with every day. This is my favorite language to use, is that it's our job to maintain inviolate the confidence and at every peril to himself or herself to preserve the secrets of his or her client. And it just talks about how important this confidentiality is, and that the preserving this confidentiality is the hallmark of the lawyer-client relationship. Comment 2 in Rule 1.6 shows that this is more than just communications with our client. It applies to information that a lawyer acquires by virtue of the representation, whatever its source, and encompasses matters communicated in confidence to us, and it's protected by lawyer-client privilege, matters protected by the work product doctrine, matters protected under ethical standards of confidentiality. All of these things are information that we are supposed to keep confidential and have duties under our professional and ethical duties and the rules to keep confidential. But the problem is we need this information, right? Our clients and defendants generally will know what happened. They know the relationships that existed before the case occurred, the incident in question, the investigation, the arrest. And so how are we supposed to use this information when we are supposed to keep it inviolate at the peril of anything else, not reveal what we've learned from our clients? So common uses of such information that you might have experience with include the pitches motion, because we need to establish a plausible factual scenario of officer misconduct, just one that might or could have occurred. And so if it's about the arrest, the only people who were there were the officers and the defendant. Generally speaking, there might be a witness, but sometimes it's very clear that the information that you are providing has to have come from confidential attorney-client communications. It doesn't take a detective to know that, but you're literally challenging a detective's work, so they should be able to figure that out, right? But we have allowances to protect the use of information there. As Alford, the Superior Court of San Diego County allows, For a pitches motion, you can make an offer of proof at an in-camera hearing or file an affidavit under seal. Another common circumstance that we use confidential information is if there's discovery from third parties, right? This is another in-camera review situation where if records are produced that have some kind of privileged information or attorney work product in them, we should have them reviewed confidentially before they're just provided to everyone. So a way that we often get around the fact that we are using confidential information is by stating on information and belief. But I don't actually like this because, like I said, it's very clear in many circumstances where this information came from. And just by putting on information and belief doesn't really remove the fact that we received this information confidentially. It just gives an out so that we aren't telling, quote unquote, out where we got it. But if we file it under seal, we can actually state what happened and how we know this, rather than just leaving it inferred by the fact the only people there were, Officer Jones and Defendant Doe. So everybody knows what's actually happening. So other circumstances that we might use this in that I think are really important are when you want opposing counsel to have certain information, but you don't want to put it in the public record, because our attorney-client privilege means that certain things just shouldn't be put in the public, right? We don't want to embarrass our clients. We have a duty not to. So these are things like when we have to provide medical records for a circumstance, if we need to provide mental health diversion treatment plans, right, that include medication doses and the type of counseling that people need to do. If you're creating individualized diversion with, the prosecutor you're working with or whoever you're working with to find a diversion that makes sense and serves justice, you might not want to give those updates on the public record, right? And so when you're and this also goes for when you're mitigating facts about sensitive matters, there are all sorts of, prior trauma that can be triggered that we don't want to talk about. And so being able to provide court and opposing counsel with these documents without making them part of the public record can serve our ethical duties of confidentiality, while still protecting that from just being generally available. So what we're going to do is file it under seal. Now, in order to file anything under seal, you must have an order from the court. You cannot do it yourself. And an important thing to note is that these can be very confusing to file. The judge in Contra Costa County who said that they'd never seen one before, it's not the first time I've gotten that, though usually it comes from a clerk. They don't know what's going on. So I highly suggest that you take advantage of the copy of Rule 2.551 that will be in the materials and keep it with you when you're filing it, when you're arguing it, everything, because that copy will be your cornerstone, because people will need to see the code. So a motion or application to seal needs to include a request that the record be filed under seal. It has to be accompanied by a memorandum of points and authorities and include a declaration containing facts sufficient to justify the sealing. Now, how do you justify the sealing, right? What are the grounds that can be established? Now, we have a defendant who, the general rule, right, is that if we seek to use an in-camera procedure or a confidential procedure, we need to give proper and timely notice of the privilege claim. We can't just make a naked claim of confidentiality, right? We have to make all the facts and circumstances clear. And to preserve a claim of confidentiality, they can be reviewed in camera, right? We don't have to reveal everything to make the claim, but we do have to give basic notice. So grounds for sealing can include the maintaining inviolate the confidence and at every peril to him or herself to preserve the secrets of his or her client, right? Attorney-client privilege. The work product doctrine, it applies not only to civil litigation, but plays a vital role in the proper functioning of the criminal justice system. And then, of course, an accused trial strategy and other attorney work product doesn't have to be provided just because we need to assert that privilege, right? So we want to protect work product, attorney-client, trial strategy, all of those things. It's very important to note, though, that when anyone is filing under seal, that we got to be fair about it, right? It's recognized by the courts that sealing limits the ability of opposing counsel to challenge the requests. And so it's noted in People v. IAEA that there are sometimes deficiencies in the presentation of factual and legal contentions. And so we just have to be very clear about all the circumstances when we do it, right? Redact only what's needed, provide the records that we can, and limit what you're working to seal while still protecting those rights, So sometimes this won't even be an issue because we'll be providing unredacted copies to opposing counsel. Sometimes you need to redact most or all of something, and just be mindful about providing all the facts. There was a statement in a case about how knowing that there would be no opposition meant people were presenting lesser arguments. Don't do that, right? Just present everything. So the actual motion or application to seal, the declaration of counsel that is required for a motion to seal may or may not have redacted portions, right? Because the records to be sealed are submitted separately, and I'll get to lodging them, but a declaration in support might include facts that allude directly to what is being sealed. So if you have a redacted declaration, ensure that the court gets a copy of both the redacted and unredacted documents, right? Sometimes it's easy to be like, oh, well, the court has the unredacted, not a problem, but they need to see what you've sealed to see if what you are redacting and what you're sealing really needs to be sealed or redacted. Now, a redacted copy has to state on the cover, public redacts material from conditionally sealed records on the cover sheet. Unredacted copies must state, typo there, may not be examined without court order, contains material from conditionally sealed record. Now, it's important that that conditionally is in there because we don't have a right to file things under seal. We need the court order, but they can be conditionally sealed, waiting for the outcome. Now, like I said, you might redact things in your declaration because do not disclose information to be sealed, right? A record filed publicly in the court can't disclose the material contained in the record that is sealed, conditionally or otherwise, because if you're stating the information that's being sealed, you've already undone all the work you're trying to do. If you're like, look, I can't tell you that my client told me that they did this, well, you've just said it, right? So don't undo your own work before you even do it. And if you need authority to say my redaction in my declaration is necessary, you can cite subsection C of Rule 2.551 to show that you can't publicly disclose material contained in the record conditionally under seal. So service of this is going to be a kind of depends circumstance, right? The actual motion and application to seal has to go both to court and opposing counsel. Unredacted records have to go to the court, obviously, right? They're going to be lodged conditionally under seal. Unredacted records have to be provided to opposing counsel if they already have access to the records, right? You can't say they can't have this when it's already in discovery, or if you want to. Some circumstances, you're only trying to keep it out of the public record, but you want to make sure that all counsel have it. So that's a sometimes rather than an always or never, right? Redacted records, of course, the court and opposing counsel both need copies of those. The unredacted records will be lodged rather than filed, not the redacted records. My apologies. The redacted records will be filed with it. They can be either filed separately as an exhibit. So pardon my chart. My unredacted and redacted notes got flipped here because the redacted records will be, the unredacted records will be lodged rather than filed because those are the confidential ones. And the unredacted records, sometimes you can attach them as an exhibit, right? If it's exhibit A or B, and you'll just put underneath filed separately, conditionally under seal, or they can be filed entirely separately as exhibits in support, right? Whatever you want. And then don't forget to have your proposed order and label for granting your motion. You always want to make sure to provide the opportunity for it to be granted easily. I always, just provide those to opposing counsel as well. Of note, who opposing counsel is might differ depending on what you're filing under seal. For instance, pitches motions, right? The district attorney isn't going to be your opposing counsel. They don't have a dog in that fight, to use an old term. So make sure that you're taking a look at who the party of interest is. Now, the tricky part of this whole process, right? We can write a motion to seal, put all of our authority, have a declaration, redact it necessarily, but what are we going to do with what we actually want to provide the court, but we don't want made public? This is where we lodge. So lodging of record pending determination of motion or application. Now, generally speaking, anything that you're asking to be sealed has to be lodged. The exceptions are if there's good cause to not lodge it, or if it's already been lodged under section 3 sub A sub I, right? Now, just to be clear, 2.551B3AI is that if the records are produced in discovery but are subject to confidentiality agreement or protective order, they can be lodged. Essentially, they're provided in response to a subpoena already under seal or conditionally under seal. So what we're going to do is I'm going to go through how to file them or lodge them in paper form, because that's generally what we're going to be doing, especially in Contra Costa County, since we don't have an e-filing for criminal. So what you're going to do is you're going to put it in an envelope or another appropriate container. I've always thought that that's kind of funny language. I imagine it might be a box if it's big enough, right? Seal it and then lodge it with the court. So what that means is that the envelope or container is labeled conditionally under seal. I have on several occasions not sealed it before taking it to the clerk's office. Sometimes I have them stamp that front page and then seal it in the envelope, or they can just stamp the cover page. That's kind of what they're comfortable with, because the cover sheet on the envelope is the important part. It's the conditionally under seal. You have to have all the information required under Rule 2.111. That's what we all have in our heading right on the left top side, our name, address, phone number, email, fax number, et cetera, right? And then the actual cover has to state that the enclosed record is subject to a motion or an application to file the record under seal. So one of the things that you're going to get in the materials is a cover sheet. And just so you guys know, I should have said it previously, I will absolutely update the service table before I provide this to everyone so that it'll be corrected when you get it. But this cover sheet isn't going to be given to anyone except the court that you're lodging it with, right? Because this is the unredacted documents that even if you're providing them to opposing counsel, they don't need the conditionally under seal cover sheet. Now, like I said, this is kind of an uncommon and confusing process. The clerk is supposed to endorse the affixed cover sheet with the date of the receipt and then retain but not record unless the court orders it filed. So what that means is that, you seal the whole envelope with its cover sheet. So, lick your envelope, seal it, or I guess it's COVID. So wet your envelope, seal it, lock it, tape it, give it to the clerk to stamp that front cover. Like I said, sometimes I ask them to stamp the inner one too. It just as received, but you don't have to. That's kind of an abundance of caution. It's up to you. But take a copy of Rule 2.551 with you. I don't know how many counties I have filed this in, and if I can't provide that copy to them, I don't get this filed, right? Because they're like, well, I can't file it if it's conditionally, you don't have an order. And I said, well, I'm not filing it, I'm lodging it, but I need you to take it, right? You almost always are going to end up talking to a higher ranked clerk unless they know you as someone who files these under seal. That's totally fine. Just because it's not practice doesn't mean it's not good practice. We can teach as we go so that these tools are used, but take a copy with you. I'm telling you, take a copy with you. Okay, now the outcome of this circumstance, it can be granted, denied, or split. I've been directed on multiple occasions to amend documents to limit like current or present redactions for further review by the court, had some of the documents granted, some denied, etc. It's important that while that's a split decision, it still counts as either they're granted or they're denied, and they have to be treated as such, right? I often will bring a motion to seal ahead of the actual motion itself. I've found that generally helps because it's not a super common procedure, but I also ask judges what their preference is, right? You know, Your Honor, I believe for the service of this motion, I am going to need to file some of the exhibits in a declaration under seal. Can we set a briefing schedule for the application motion to seal prior to the motion itself? Because obviously how you write the motion is going to change depending on whether or not you can keep sections redacted and file exhibits under seal, or whether or not you have to find ways to present that information in ways that don't violate privilege. But the important thing is that once you're actually there, if it's granted, if the court grants your application to seal, then there has to be the proposed order that you've used and specific behavior on part of the clerk to keep those things filed, move them from lodged conditionally under seal to filed under seal. Or if it's denied in whole or in part, the lodged record must be returned unless the moving party requests otherwise. So I'll get into that. So if it's granted, right, the envelope or container must be labeled with a label that states sealed by order of the court on, enter the date here, right? So just leave that blank, write date there. I haven't done this with like a label, like a sticker label, but you could probably include one if you wanted that. Or honestly, the court could probably write this on it, but it's always nice to provide something to cover the prior conditionally under seal, right? So the cover sheet will show conditionally under seal on it. You want to be able to slap a new label on there so that it's no longer conditionally, but actually sealed. And then the cover sheet of the envelope has to be replaced with a file endorsed copy of the court's order. So make sure you have an order so that it can be sealed. Got to make sure to provide that. If it's denied, though, there are two choices, both the moving party's choice, right? The moving party can specifically request a modification of their application within 10 days of the order denying the motion or application to seal, right? So basically, while the court can say, I need that modification request within 20 days or within 5 days, the statute says 10 days, that's what the court can change. But it is only the moving party that can ask for a modification of the application to seal. The clerk either has to return the lodged record to the moving party if it's in paper form, or permanently delete the lodged record if it is in electronic form, right? So if I, as the moving party, don't specifically say, hey, I'd like a modification, I want you to file it, I want it just to be included in the file, it has to be returned to me and or deleted entirely from the electronic record. It cannot be revealed. The rules require that they be returned to the moving party. I include this explicitly in my moving papers because I have had judges threaten to release these lodged records to opposing counsel upon denial of my application, right? But they can't do this. They are not allowed. They have no grounds to do so, so be ready to defend that, right? The modification, on the other hand, can be submitted within 10 days of the order denying the motion or application to seal, or whatever period the court orders. And essentially that's the moving party notifying the court that the lodged record is to be filed unsealed, right? Like, oh, okay, my motion to seal didn't work, that's fine. Clerk, please unseal it, include it in the record. And the clerk must unseal it and file it. They have to, if you are denied that motion to seal. So this isn't a common process, but it is useful, right? I really like to do all of my mental health diversion status updates and treatment plans under seal. And I've actually been thanked by prosecutors in the court for doing so, right? This is sensitive information, and it's, you know, the circumstances that really have diversion serving justice. And so making sure that that's not just part of the record, and that we are complying with our ethical duties to keep those attorney-client conversations confidential, we do that, right? Now, it seems like I kind of busted through all of those slides. But it's not actually a complicated process, right? It just isn't commonly done, but there's no reason for it to be hard. So I guess I'll just go over real quick that when you do these can be the tricky part. Sometimes you'll just include them, you know, as filing an exhibit for a motion conditionally under seal. But I find that if you redact something and lodge something conditionally under seal, often opposing counsel and the court will kind of freak out if they don't have any notice that this is going to happen. And so it is important to talk to the court about when the best time to file these is, so that you can actually, you know, have it work and have it be helpful and help your clients. So if anybody has any questions or experiences that you have with trying to file something under seal, I would love to be able to answer them, address them. Like I said, it's not actually a very complicated process. It's just one that I guess isn't used. And you know, there's no reason for us not to be using it. There's lots of information out there that we shouldn't be sharing with the public that is super helpful to our clients, or generally, you know. I'm just fixing the service doc slide over here. So.
Thanks, Ashley. I just wanted to let anybody know if anybody does want to, you know, speak out loud and talk about their experience, just let me know and I can, you know, unmute you. If anybody's got anything that they would like to share with their experiences.
I mean, from either side, I know sometimes it's tricky to defend against something that's sealed, and knowing, you know, what feels better if a counsel does file something under seal, how to address it. You know, it's one of those that can feel really tricky, but there's a lot of confidentiality out there, right? And we have ethical duties to protect that information. No.
All right. Well, if there's nothing from our attendees, I think we can wrap up and give everybody back a little bit more of their lunchtime. Ashley, thank you so much. You packed a lot into a short amount of time. I think this will be really valuable for folks.
Sorry if I talk too fast, y'all. I guess I should have slowed down my presentation here, but Like I said, all of the information that I went through, right, there's a lot of information on those slides. It'll all be available to you so that you have good points and authorities. You should be able to essentially pull your application to seal from these slides. It's a useful thing to have in your back pocket, especially, like I said, for mental health diversion. I often kind of point of practice, I'll often ask at status updates for mental health diversion for the judge just to include an order to seal on the minute order, right? If we have another update set for 6 to 8 months out, just to include it so that I have that permission already from the court to file under seal, so that it is all there, you know. But if nobody's got any questions, comments, or anything like that, I guess we can just give you your lunch hour back and hope that this is helpful.
I think that sounds